Hello everyone. Today I will present the case of Sewell versus Burdick, which happened in 1884, a landmark decision of the House of Lords reported in 10 appellate cases 74. This case is important in commercial and maritime law because it clarifies whether a bank that receives a bill of lading as security becomes liable under the contract of carriage. The decision shaped modern trade finance law and influenced later legislation, including the Carriage of Goods by Sea Act 1992. So, the parties in this case are appellants Sewell and nephew, the ship owners, and respondent was James Burdick, representing the bank that had taken the bill of lading as security. The dispute eventually reached to the House of Lords, which was the highest court in the United Kingdom at the time. So, key fact of the case. The goods were shipped from London to Putney under the bill of lading. Putney is a Georgia in our time. The bill said that the delivery was to be made to the shipper or his assigns, and the freight and the charges were payable at the destination if the owner defaulted. A merchant named Nercesson deposited the bills of lading in blank with the bank in Manchester as security for a €300 loan. The bills were endorsed to the bank. When the goods arrived at Putney, they were placed in a Russian custom house. However, Nercesson disappeared. After about 1 year, customs authorities sold the goods to recover duties and charges. The sale only covered customs expenses, leaving the freight unpaid. The ship owners then attempted to recover freight from the bank. So, at trial, Justice Field decided in favor of the ship owners. However, the Court of Appeal reverses that decision and ruled in favor of the bank. The case was then appealed to the House of Lords, which delivered the final and authoritative judgment. So, we have some legal issues in that case. The first one is the bank liable for the freight simply because it holds or endorses the bills of lading? Secondly, was the transaction a transfer of ownership, meaning a mortgage, or merely a pledge? And the last one, did property in goods pass to the bank within a meaning of Section 1 of the Bills of Lading Act 1855? These questions were crucial because under the 1855 Act, if property passes, right and liabilities under the carriage contracts also pass. So, let's see some differences between mortgage and pledge distinction. The court made an important distinction between a mortgage and a pledge. A mortgage means a full legal ownership transferred to the creditor. A pledge, however, creates only a special property or security interest. The creditor holds the goods as collateral but does not become the absolute owner. The House of Lords needed to determine which category applied to the bank in this case. And the decision of the House of Lords. The House of the Lords held that the word property in the Bills of Lading Act 1855 meant absolute ownership, not a limited security interest. The transaction between Nercesson and the bank was only a pledge. The bank did not intend to purchase the goods, it only wanted security for the loan. Therefore, property in the goods did not pass to the bank. As a result, the bank was not a party of the contract, the carriage, and was not liable to pay freight. So, this decision was extremely important for commercial law. If banks had automatically become liable for freight simply by holding bills of lading as security, trade finance would have been very risky. The ruling protected banks from disproportionate shipping claims. It allowed bills of lading to remain flexible commercial instruments. This encouraged international trade because banks could safely finance shipments while goods were still at sea. So, the principles from this case influenced modern legislation, especially the Carriage of Goods by Sea Act 1992. Under modern law, a lawful holder of a bill of lading may sue the carrier. However, liability for freight generally arises only if the holder claims delivery or takes possession possession of the goods. Thus, the balance between protecting ship owners and protecting commercial lenders remains today. In conclusion, Sewell versus Burdick established that liability under a bill of lading does not automatically transfer with possession of the documents. Only absolute ownership, not the mere security interest, transfers contractual liability. The House of Lords carefully balanced commercial practicality with legal principle. This case remains foundational authority in maritime and commercial law and is still cited in discussions about trade finance and carriage of goods. Thank you for your attention. Please don't forget to like and subscribe to our channel.